Hello and welcome to a webinar on the top 10 employee handbook mistakes. My name's Laura and I'm in compliance at Backtrack. We're pleased to have John Hyman back with us presenting this webinar today. A couple of housekeeping things before we get started. The live webinar is eligible for one general recertification credit through the Human Resources Certification Institute. Please be sure to fill out the survey at the end of the webinar and we'll email the certificate to you later in the week. This webinar is being recorded and will be sent to all who registered for it. It will also be available on the Backtrack website. And if you have any questions during the webinar, please type them into the control pane and they will be answered at the end of our webinar. So now, thank you, John. I'll turn this over to you.
Thanks. Good morning, or good afternoon, I guess, everybody. It feels like morning, maybe. I don't know. It's good to be back with everybody today. For those of you who are here for the first time with us, my name is John Hyman. I'm a partner with the law firm of Meyers Roman, Friedberg, and Lewis. Here in Cleveland, Ohio. We're actually in Woodmere, just outside of Beechwood. I am a management side labor and employment lawyer. I've been practicing in this area for close to 20 years, representing companies of all shapes, sizes, industries, defending discrimination and other litigation brought by employees, and then helping companies on the more proactive side with writing policies, training, internal investigations, and what have you. And then in my spare time, the spare time that I have, I maintain a blog. I write the Ohio Employers Law blog, www.ohioemployerlawblog.com, the info of which is going to be on the last slide, along with all my contact info, where I write 5 days a week on a lot of what we're going to talk about today, which is the top 10 employee handbook mistakes. And, you know, in the nearly 2 decades that I've been practicing management side labor and employment law, I've reviewed, you know, hundreds, if not thousands might be a little aggressive, but, you know, hundreds of employee handbooks, you know, of companies ranging from you know, those that are, you know, 2, 3, 4, 5 employees, all the way up to handbooks for companies, you know, $500 million publicly traded companies that has a handbook that applies to, you know, 50,000 employees around the world. And what I have put together today are what I've seen repeatedly in employee handbooks that I reviewed. Mistakes that I see repeated over and over again that companies make. A lot of them are because companies have not kept up with current trends in the law. We're going to be talking about that. A lot of them are because companies haven't had handbooks reviewed in a long time. A lot of them because companies do these things kind of, they try to, you know, save a few pennies and DIY these things, and I'm not here at least expressly to try to sell legal services. But I will tell you that, you know, bad handbooks lead to, you know, uncertainty with both management and employees. They lead to poor management-employee relations, and maybe most importantly, as we're going to talk a lot about today, poorly drafted handbooks open up companies to a tremendous amount of risk and liability. There's a whole bunch of laws that require certain policies in handbooks, or require that if you have a certain policy, that the policy say certain things, or at least not say certain things. And we're going to be talking a lot today about not just from a best practices standpoint in terms of what are some good things to have in your handbook, or why some things make sense and to have or not have in your handbook, just from a employee relations or a kind of management rights standpoint. But we're also going to be talking about some things that if you don't have them in your handbook, the law is going to punish you, or if you do have them in your handbook, but you have it worded incorrectly, the law is going to punish you. And so that's kind of the lay of the land in terms of what we're going to talk about. These aren't in any particular order. It's not like a, you know, it says the top 10 mistakes, but I'm not David Letterman. We're not going to start at 10 and work our way up to number 1. It's just kind of a general, kind of these are the 10 things that I see repeated over and over and over again in handbooks. And, you know, starting with number 1, we're talking about missing at-will disclaimers. So real quickly, and I know I'm probably going over, some of this is going to seem really basic to some of you. Some of it's and for some of you it won't, but in Ohio, all states except for Montana are at-will states, which means that companies have the right to, fire an employee for any reason, good, bad, indifferent, or otherwise, provided that the reason isn't otherwise made illegal by some law like discrimination or, protected whistleblowing or something like that. If you have an employee handbook, one exception to the at-will rule, when you can't fire an employee without just cause, a good reason to do so, is if you have a contract of employment with that employee. And a lot of employees misperceive that their employee handbooks are those contracts of employment. They're not, usually. They are kind of a set of, if they're drafted correctly, they're a set of guidelines for a company to follow, kind of rules of the road, but not, if it's drafted the right way, certainly not binding on the company in terms of a contract that the company has to in all circumstances follow, and it's open to being sued for breach of contract or some other breach of a promise if the company doesn't follow the handbook. But I will tell you, I see lots of handbooks that I review, not ones that I draft, but ones that I review for companies where at the beginning there's no disclaimer, and then when you get to the end, there's nothing the employee signs, recognizing that what the document they're being given is not a contract of employment that modifies the at-will relationship. And if it is a contract of employment, if you're missing the disclaimer language, we'll talk in a second about what that disclaimer should look like. But if you're missing that disclaimer language, an employee can reasonably rely on that handbook as a binding agreement between the company and the employee, and it's going to severely hamper the employee's relationship, or hamper the employer's ability, rather, to terminate that employment relationship with the employee. And every couple of years we see a case pop up where an employee says, well, I was given a handbook and I thought the handbook was a contract, and they fired me and they didn't follow their discipline procedure, and therefore I should have the right to sue for a breach of this contract between me and the company. The last one I saw involved the Mount Carmel Health System down in Columbus. They had an employee handbook. The employee handbook said things like, all employees are employees at will. The employee or the employer can terminate the employment relationship at any time for any reason. No statement in this manual will be interpreted or applied as a contract of employment. Pretty clear statement right in the handbook. In addition to that, you have the employee signing a document, a piece of paper, usually the last page in the handbook, tear it off, stick it in the personnel file. The employee signs it, that basically says the same thing. I recognize that the company has the right to change provisions in this manual or handbook at any time for any reason. No one has the authority to make an agreement with me for any reason, whether it's consistent with the handbook or contrary to the handbook, unless it's in writing and unless it's signed by the president of the company. This handbook is not a contract of employment. I, the employee, understand that the company can fire me for any reason at any time. I can resign for any reason at any time. And then we don't have a binding contract, right? That's what these things typically say. And in the case that, the last case, at least in Ohio, that I saw discussing this issue, that was the language, and the employee who was fired sued, saying breach of contract, and the company ran into court with the handbook, and the court had really not much of a problem dismissing the case, saying, yeah, your company, employer, you're right, not a contract of employment. Look at all the things you say where you say it's not a contract of employment, and the company or the employee shouldn't be relying on it as a contract of employment. So, what kind of things are we looking for in these at-will disclaimers, both in the handbook and then on the sheet that the employee signs? What do I want to see as a litigator if I get sued? A client gets sued by an employee or a former employee. I want to see that employee's John Hancock or Jane Hancock right there on the piece of paper in the personnel file, where they say, I got this handbook on this day, and I understand, number one, I'm an at-will employee without exception. Number two, a plain English explanation of what at-will employment means, because that's a legal term. Employees aren't going to understand it, so you got to tell them At will means you can quit at any time for any reason, and we can fire you at any time for any reason, period. A statement that no one can create a contract with the employee, period, whether it's contradictory to the employee handbook or not. And you may want to say, you may want to have situations when you can have a contract for, high-level executives, whatever, and then you would say something like, unless it's signed by the CEO or the president of the company, in writing, period. Okay. A statement that the handbook is merely a unilateral statement of rules and policies, which creates no rights for the employee or obligations of the company. It's, guidelines, principles to follow, but not a binding hard set of rules that's doctrine that the company or the employee, for that matter, it should work both ways, has to follow all the time. A statement that the handbook is not a contract, not intended to create a contract of employment. A statement that the employer has the unilateral right to amend, revise, or eliminate policies or procedures as needed. And then finally, a statement that employees should not rely on any statement in the handbook as binding on the company, because you don't want, in law, we call it promissory estoppel, where somebody makes a promise that someone else relies on to their detriment, even if the promise doesn't rise to the level of a binding contract. You can still enforce the contract, or enforce the promise, rather, based on this idea of detrimental reliance. We don't want somebody relying on the handbook and trying to say, well, I relied to my detriment, therefore you made a promise that damaged me. So you want a statement in there about, no reliance as well. At-will disclaimers, really easy to get right. Really, really big consequences if a company gets it wrong. Number two, probationary periods, and we see this a lot in employee handbooks where, and this kind of builds off this idea of at-will employment and disclaimers. We see this a lot in employee handbooks where the handbook says to an employee, for your first 90 days of employment, you're a probationary employee. You can be fired at any time for any reason during those 90 days, and then after those 90 days are over, you become a non-probationary employee. This is, and if you think about it logically, right, you're telling someone for the first 90 days you can be fired at any time for any reason. Think back 2 minutes, that's the definition of at-will employment. Everybody's an at-will employee, unless for some reason they're not, right? You might have, the president of the company, the CEO, might have a contract that says we're going to employ you for 3 years. He's not at will. He has a contract for a period of time. But most of your employees are going to be at will, and so how does that at will employment differ at all from what you're telling them, or how you're telling them they're going to be treated for the first 90 days? And are you, setting up some kind of unreasonable expectations whereby, for the first 90 days you're probationary, you look like an at will employee, we can fire you at any time, at any reason during those 90 days. Are you some kind of super at-will employee when those 90 days expire? How are you different? But by having this probationary period, you're making employees think that they're different. And we see this is kind of a holdover from union contracts, collectively bargained relationships. Those employees aren't at will. They can be fired, at any time for any reason. Or rather, they can't be fired at any time for any reason. They can only be fired for just cause if they're a union employee under a collective bargaining agreement. Union contracts have these probationary periods in it because, when you hire someone new, you want to have more flexibility. You don't want to be bound by a just cause standard. And so these probationary periods that we see in handbooks are kind of carryovers from this collectively bargained environment, but in a non-union setting, these probationary periods just really play no role. You're at will from the day you're hired, and whether you're there 30 days, 60 days, 90 days, or 10 years, your status as an at-will employee doesn't change. So my advice to companies, when I write handbooks to review them, I scrap the probationary period, and I see these in a lot more handbooks than I don't. And what I put in their place is not a probationary period, but rather your performance will be reviewed at the 90-day mark, and and then every year thereafter on the anniversary date of your employment or whatever your performance review policy says or practices. That way, you have this 90-day check-in. It really serves the same purpose. You have their probationary period because you want to have a check-in with the employee. You want to figure out what are they doing right, what are they doing wrong, are they a good fit, do we want to keep them employed, is now a good time to sever the relationship just because they're, you know, I mean, hiring's a crapshoot. You never know what you're going to get really until you get the person in there. Did we make a mistake in hiring this person? Do we want to cut ties now? A review at 90-day mark serves all those purposes, and doesn't set up the unreasonable expectation that at the 90-day mark there's something other than an at-will employee. And progressive discipline, you know, it really it's kind of the same idea. I mean, as an at-will employee, and this is mistake number 3, progressive discipline policies. Again, a holdover from a collective bargaining agreement where you have steps in place. First mistake, you know, counseling. Second mistake, oral warning. Third mistake, written warning. Fourth mistake, termination or whatever. You know, you can build as many or few steps as you want in a traditional progressive discipline policy, and you have that in traditional collective bargaining agreements because the unions bargain for job security for their employees, and this is one of the ways they do it by saying, you know, except for the most egregious of mistakes, we want the employees to have notice before you're going to let them go for something, and so we have steps built in, progressive steps built in this discipline process. That idea that started in these collective bargaining agreements has got carried over into a lot of handbooks that have been, you know, that I see, and it's just not necessary. At-will employment, fired at any time for any reason. You don't want to give employees protections that they don't need. You don't want to say the first time you make a mistake, we're going to give you you know, we're going to pull you aside and talk to you and give you an oral warning or counseling. And the second time we're going to give it to you in writing, and the third time we're going to give you a final written warning, and then the fourth time you make the same mistake, we're going to fire you. Because maybe, you know, you want to fire the person when they make their first mistake. Maybe, you know, maybe you want to have the flexibility to fire as you see fit. And so there is, you know, I put this idea of progressive discipline into handbooks because it's kind of a warm fuzzy for employees, but you want to have flexibility in how you write it. So you don't want to say, the first time we will do this period, the second time period, the third time period. You want to say, here's a list of all the reasons why, and not exhaustive, not exclusive list of all the reasons why we may choose to discipline or terminate you. And for any one of these reasons, at any time, we may, in our discretion, give you an oral warning, give you a written warning, counsel you, or we may fire you. And it's up to us, so we're going to choose how we do it on a case-by-case basis, per employee, per violation. A lot more flexibility for companies. You know, you don't want to be doctrinal with these handbooks where even though the handbook says we're not a contract, nevertheless, you know, you're going to have major employee relations issues if the handbook says we're going to give you 4 cracks at the apple, but you start firing people for the first crack. You want to have flexibility. You want to maintain your, you know, under at-will employment, you have discretion. You want to make sure that your discipline policies maintain that discretion and don't unnecessarily give it away. Mistake number 4 is ineffective harassment policies, and let's take a step back because the most ineffective harassment policy is not having one at all. Okay, some states like California require you to have a harassment policy and annual training for your employees on workplace harassment or workplace harassment, I guess. I always think it's funny when you say we're having harassment training, it sounds like you're telling people, yeah, we're going to train you how to harass. It's a harassment prevention training, is a more accurate description. Some states like California require that. Ohio's not one of those states, but this is, again, one of those areas where not having a policy, even though the law doesn't require the policy, is going to get, you know, has the potential to get you in legal trouble because even though the law doesn't say that must have, you know, Ohio employer, that must have a sexual or workplace harassment or anti-harassment policy, the law does say if you have a policy and it sets up certain reporting measures for an employee to follow if the employee believes they're a victim of harassment, and that employee has not suffered a job loss as a result of the harassment. They're just believe they're subjected to a hostile environment but haven't been disciplined or terminated or what have you, and they fail to take advantage of that harassment policy to complain about the harassment. No matter how hostile the environment might be, employer, you're off the hook if you have the policy and the employee failed to avail him or herself of that policy and hasn't suffered a job loss as a result of the harassment. So, so for that reason, having a harassment policy, even though it's not, the law doesn't say that you must have this policy, because the law nevertheless gives employers a defense for those that have the policy. I think it's negligence, gross negligence, recklessness even on the part of an employer if it does not have a harassment policy. If it does not have a harassment policy in its handbook, the harassment policy needs to be effective, right? Now, having it is great, but it has to work, right? The policy can't just say don't harass, right? You need to explain to employees what harassment is. You have to tell them on what bases harassment is not tolerated in the workplace. So, for example, right now in Ohio, sexual orientation, not discrimination, not prohibited by law yet. The EEOC has taken the position that Title VII, the federal employment discrimination law, even though it doesn't include sexual orientation and gender identity, LGBT rights, the EEOC, Equal Employment Opportunity Commission, takes the position that it's the same as sex, and so they're treating it kind of all the same. But do you want to include sexual orientation, gender issues, gender identity issues, transgenderism, in your EEO and anti-harassment policies? How are you going to tell your employees that harassment in the workplace, is zero tolerance, black and white? I think you should, right? And there's a lot of, there's a lot of black and white in the area of harassment. Is it because of sex? Is it because of race? Is it severe or pervasive enough? There's lots of gray areas where you can argue, I can argue on your behalf if you get sued, that this doesn't rise to the level of actionable harassment. You don't want those gray areas in your policy. You don't want employees making judgment calls over whether the law makes this illegal harassment or not illegal or lawful harassment. Courts say all the time, the employment discrimination laws aren't a workplace civility code. Employees should have to put up with some level of annoyance, discomfort in the workplace. And we're only regulating things that rise to the level of being severe or pervasive. Severe, the most egregious harassment you can imagine. Physical groping of a man, of a woman by a man, or using racial epithets to describe someone, someone's race. Hanging a noose up in an African American person's locker. Those are the kind of things that even one time because they're so severe, are going to be actionable harassment. Pervasive, not quite as severe, but happens a lot, right? You don't want employees making those judgment calls. So what you want to tell your employees in your harassment policy for it to be effective is, this is a zero tolerance workplace. We are, you need to put on your best brain filter when you come into work, and you need to really think before you say anything. And if you think something has the most remote chance of offending someone, you keep your mouth shut and don't say it. You need to make sure employees know that they have an obligation to report harassment, whether they're the victim or they see it, right? If someone is not the victim of some harassment but nevertheless sees it, as a witness to it, they should feel obligated to report it to HR or to management. You need to have a clearly spelled out complaint procedure and what the company is going to do when a complaint comes its way, so that employees know who to go to. And the policy, the procedure should be not just report harassment to your supervisor, because what if the supervisor is the person that's alleged to be perpetrating the harassment? Multiple points of communication touches for a harassment complaint. HR, your manager, your supervisor, anyone in management, all the way up to the CEO or the president of the company, everyone's door needs to be open to receive a complaint of harassment, and that should be spelled out in the policy. Confidentiality as much as possible. When someone makes a complaint of harassment, hold that thought to the last flyer. We're going to come back to it because there's some nuances with how confidential you can keep a harassment investigation or complaint based on what the National Labor Relations Board is doing. And lastly, and maybe most importantly, no retaliation. Make sure your employees are told as many times as possible for it to be clear that you are a zero harassment workplace, that they have the absolute right to come forward with a complaint of harassment without threat or fear of reprisal, retribution, retaliation, that nobody will be disciplined, terminated, demoted, what have you, if they make a complaint of harassment, give information about someone else's harassment complaint, just retaliation. I can't tell you how many times I have seen companies that have one discrimination cases, one harassment cases. Yes, employer, you did not fire that person because they were African American. You did not condone or tolerate sexual harassment against a female employee. You're off the hook for the discrimination and the harassment. But when that person complained to you about harassment, they were demoted, they were fired, they were whatever. When they went to the EEOC to file a discrimination charge, a month later they lost their job. So many times companies win the underlying discrimination harassment case but lose the retaliation case. And vitally important for you to not just have it in your policy but live it every day, that you have to be absolutely zero tolerance on harassment. These policies don't work if employees have fear in filing complaints, either internally or externally, and you cannot have a culture where retaliation is tolerated. Period. Okay. And let me make one more point about harassment policies, which is that the policy also has to be understandable. So and what I mean by that is you have a bilingual workforce. You can't have a harassment policy that's just in English. You probably need to make it available to in whatever other languages your employees speak, so that they can understand what the policy says and what it means. If you employ a lot of teenagers, you probably want to have a policy that's not just a formal harassment policy. You might want to have a simpler, more simply written policy that a 16-year-old can understand better than something that a 35 or 45-year-old person is going to understand. So not enough to just have the policy, but also to make sure the policy is communicated and understandable. Okay, inflexible leave policies. What does this mean? Let's say whether you are an FMLA covered employer, that is, the law says you have 50 or more employees within a 75-mile radius, and so the law says you have to give 12 weeks of unpaid leave to somebody who, for their own serious health condition, that of a family member, birth of a child, placement of a child for adoption, what have you. Or if you're not FMLA covered, but you give leaves of absence to employees under the Americans with Disabilities Act as a reasonable accommodation. Either circumstance. With one exception we'll talk about later, this is probably the mistake I see the most in employee handbooks, which is policy that says 50 or more employees, we will give you 12 weeks of unpaid leave for FMLA qualifying reasons, period. Thereafter, if you need more leave, we may, we reserve the right to deny it and terminate your employment, or your employment will be terminated. Small company or FMLA company that gives leave in excess of 12 weeks, we'll grant leaves of absence up to 3 months, period. Or we'll grant leaves of absence up to 6 months, period, whatever the case. Each and every one of those policies violates the Americans with Disabilities Act. EEOC just last week or the week before, sometime this month, published guidance on leaves of absence under the Americans with Disabilities Act, and the ADA and the EEOC says, and courts say, and the ADA says as follows: for an employee who is disabled, that is, an employee who has a physical or mental condition that substantially limits their ability to engage in one or more major life activities. For someone who is disabled under the ADA and needs a reasonable accommodation to enable them to perform the essential functions of their job, you have to engage in what's called the interactive process with those employees, meaning that you have to sit down with the employee and you got to talk through possible accommodations that will enable the employee to perform the essential functions of his or her job. In almost every case, if an employee needs it, in order to be able to come back to work, an unpaid leave of absence is going to be a reasonable accommodation. If it's an FMLA leave, you may have to consider a leave of absence unpaid beyond 12 weeks. If you are non-FMLA or the employee has exhausted his or her FMLA leave, you nevertheless are likely going to have to consider an additional unpaid leave of absence as a reasonable accommodation. If you have a policy that puts a hard cap on that leave of absence, it's inflexible in how you work with employee leaves of absence. We will grant 12 weeks period, no more. We will grant 6 months period, no more. After X number of days or weeks or months, we can't guarantee you're going to have a job if and when you're able to come back. The EEOC says that policy, because it is hard capped, because it's inflexible, shuts down the interactive process. It makes it such that the employer, on its face, is telling employees, we're not going to engage with you to figure out what accommodation you need. Policy says X, is there in black and white, that's what we're going to do. And so because of that, the EEOC says, and I agree with them, that these maximum kind of inflexible, hard-capped leave policies on their face violate the ADA, because you are right there in the handbook avoiding your obligation to engage in this interactive process. So what you want to say instead is, rather than we will grant leaves of absence of this duration period, what you want to say is, we will grant leaves of absence of this duration and then consider whether additional leaves are required on a case-by-case basis, period. Unpaid leaves, our employees are not entitled to unpaid leaves in perpetuity. They have to have an end date. But if an employee gets a medical certification from a physician that says, I need to be out for 3 months, you grant the 3 months as an accommodation. If they come back at the end of the 3 months with a doctor's note that says, I need an additional week, you're going to have to grant that additional week because it's reasonable. Now, at some point, as those weeks add up, if every week the employee is coming back with a note that says, 1 more week, 1 more week, 1 more week, kind of in serial, eventually it's going to flip the switch to being unreasonable the more you extend this leave out or the longer the leave is. But that's on a case-by-case basis. There's no hard and fast rule on what the law says. What the EEOC says is that you have to, you can't put hard limits. You have to work with employees in order to determine what leave is appropriate for an employee on a case-by-case basis for that particular employee. Next mistake. This is number 6, I believe, halfway through. Vague FMLA language. Family Medical Leave Act says employees get, for employers that have 50 or more employees within a 75-mile radius, employees that have worked at least a year for the company non-contiguously. That means they can work 6 months 5 years ago and then come back and work 6 more months. That counts as 12 months. Who work 12 months for a company and then at least 1,250 hours in the preceding 12 months are eligible for 12 weeks of unpaid leave for various qualifying reasons. The FMLA says you need to in your handbook, if you are an FMLA covered employer, you need to have an FMLA policy in your handbook, period. And the Department of Labor goes so far as to even publish one on its website. You can just go pull it. It is a legally compliant FMLA policy for you to drop into your handbook, and I'd venture to guess that if you had a lawyer write your handbook for you, and I'm not so proud to admit it either, that the policy that will show up in your handbook is almost certainly going to be the one or a variation of the one that's on the Department of Labor's website. in addition to that policy, and that policy has various options, you can kind of select from a menu of various things to include in your policy. So for example, are you going to require employees that have paid time off accrued to run that paid time off concurrent with their FMLA, or are you going to let them use it, keep their paid time off and then use it in addition to their FMLA when their FMLA expires? That's one option you have. Another thing you have to do is tell employees how you're calculating the 12-month FMLA period. Everybody, all eligible employees of FMLA-covered employers get 12 weeks of leave per year for some qualifying reason. And the question is, what does a year mean for purposes of the FMLA? And the FMLA gives you 4 choices, and the point is you have to pick one in your policy, because if you don't pick one, your policy is silent on the issue of how we calculate those 12 months, then a court is going to pick it for you if you're sued, and the one they're going to pick is going to be the one that works out to the employee's benefit in that particular case. So what you want to do is in your FMLA policy, tell employees how you're calculating that 12 months. Department of Labor, the FMLA gives you 4 options. You can use a calendar year, that is January 1 to December 31. That's our FMLA year for purposes of everybody's 12 months of FMLA time. And then every January 1, the switch flips. We can use any, that's option 1. Option 2 is any fixed 12-month quote-unquote leave year. So you can use, just pick an arbitrary date. We start our FMLA year on July 1. You can use your fiscal year. You can use the, each employee's, hire date as their FMLA year. Option number 3 is a kind of a 12-month look forward from the first date that any employee uses FMLA. So for every employee is going to have a different start date. So if I use my FMLA, today's May 17. If May 17 is the first day I use FMLA, then that's when the FMLA year starts for me. And every May 17, my FMLA is going to or May 16, my FMLA is going to expire. May 17, it's going to reset itself. The problem with rules 1, 2, and 3 is that it allows for a kind of a rollover because it has a fixed start point and a fixed end point. It gives the potential for more than 12 weeks of FMLA in any contiguous 24-month period. So if I take the calendar year, for example, if I have a back injury that takes me out of work, I get in October, November, December, there's my 12 weeks. Now the calendar switches to January 1. I get 12 more weeks of leave. And now what I could actually do if I'm medically certified is run 24 contiguous weeks of FMLA leave. The 4th option, which is the most advantageous to employers and the one that I always recommend that employers use, even though it is administratively the most difficult, is the only one that prevents against this allotment. This prevents against an allotment of more than 12 weeks of contiguous leave, and that's what's called the rolling 12-month leave period. And the way that works is when an employee puts in a request for FMLA leave, you look backward to the preceding 12 months, and you see how much FMLA time the employee used in the preceding 12 months, and that's how much time they have left to use. So today's May 17. If I put in a request for FMLA today, under this rolling period, the company is going to look back until May 17 or May 18 of 2015 to see how much FMLA I've used in that 12-month period. If I've used 6 weeks in that 12 months, I mean, I'm going to have 6 weeks left to use. That is the most advantageous because it prevents against this, again, this kind of possibility where on a bridge between 2 leave years, you can have an employee that has more than 12 weeks of leave available for a medical issue. But again, this rolling year is the most administratively burdensome because it requires some extra work every time an employee makes a request for leave. But nevertheless, administrative burden aside, that's the one that I recommend companies use. That's the one I write into policies when I'm given the opportunity to recommend an FMLA policy for companies. Number 7 is missing, incomplete, or overly restrictive no solicitation policies, and this is another area where the law kind of dictates, creates problems when you have policies that have not been reviewed. If your handbook's been on your shelf for the last 5 years, if your handbook's been on the shelf for the last 3 months, your handbook may actually violate federal labor law in the area of no solicitation policies. We just, just a few months ago, the National Labor Relations Board took a look at employee no solicitation policies. That is, and we're talking about restrictions on when non-employees can come onto your property or have access to your employees for purposes of any, giving them any solicitation. We think of it, it could be charitable requests. It could be, we think of it when I have my labor law hat on in terms of non-employee union organizers trying to distribute pro-union literature to your employees. And this is just, 2 months ago in March, in a case involving Dish Network, the satellite TV provider, the NLRB looked at the following no solicitation policy, and I'm going to quote it for you. In the interest of maintaining a proper business environment and preventing interference with work and inconvenience to others, employees may not distribute literature of a personal nature by any means or solicit for any other reason during work time or in work areas, except as specifically authorized in advance by a vice president or higher. Employees who are not on work time may not solicit employees who are on work time. Pretty reasonable. It made a clear distinction between work areas and non-work areas, work time and non-work time. And up until 2 months ago, that is a policy that if a client brought that policy to me and said, this is what's in our handbook, is it okay? Or we found this online, is this okay to use? In our handbook for no solicitation, I would have said, yeah, it's fine. It passes muster under labor laws. You're not discriminating against, obviously you can't have a policy that says no union solicitation. That's discriminatory. On its face, it's not discriminatory. You're making distinctions. You're protecting your work areas and work time. Pretty reasonable policy. I think it's okay. The NLRB 2 weeks ago, or 2 months ago rather, disagreed and found that policy was unlawful. It said it was, because it was a blanket prohibition of all work area solicitations, including those work area solicitations that occur during non-working time, it's unlawful. And also it's unlawful because it requires obtaining management's approval before embarking on solicitations in work areas, whether you're off the clock work areas. And so because, and so what the NLRB did in this case was it expanded the areas in which individuals can solicit for non-work related purposes, not just to non-working time, but even to working areas on non-working time. 2 months ago, I would have said working areas were off limits for solicitations. Now that's not the case if it's off the clock. Last year, the NLRB went even a step further, and in discussing solicitation rights of employees of other employees, in the context of email systems, the NLRB said that if you give employees access to your corporate email system, you cannot deny them the ability to use that system during non-working time for union-related purposes. And so if your employees have access to your email, they have a abcco.com email address, and they want to use that email address to talk to their coworkers when they're off the clock about all the benefits a union would provide and how great unions are, and signing those authorization cards. As an employer, you have to give them the right to do that. You can't deny them that right, even though your email system is your property, it's your system, you control what goes over it. You cannot deny employees the right to use it for union-related purposes if you open it up for their use for any other reason, whatsoever. Number 8 in handbook mistakes that we see a lot of is lacking overtime controls. And what do we mean by lacking overtime controls? We're talking about not having a statement by which when employees are or are not permitted to work overtime, and what rules an employee has to follow when an employee works overtime. The leading case in this area comes right from our very own Sixth Circuit Federal Court of Appeals here in Ohio, White v. Baptist Hospital. And in the White v. Baptist Hospital case, the company had a policy under which all employees received a daily automatic unpaid meal break. So every day the employees, hourly employees clocked in, and every day 30 minutes would come off the top for their unpaid lunch. They didn't have to clock out, they just came off the top, and they weren't paid for 30 minutes a day. That was their lunch period. The policy also provided, though, that if an employee worked through this unpaid meal break or had a meal break interrupted for some work-related reason, the employee would be compensated for that time worked, and the policy expressly instructed the employees to record all the time they spent working during their meal breaks in an exception log, which would then be used by the payroll department to calculate giving back this unpaid time to employees. The plaintiff in the case, Ms. White, sued claiming that she wasn't paid for all of these missed lunches. Her supervisors knew when they made the request, they knew when she was working through lunch. She admitted she didn't use the exception log, she didn't report this working time, but nevertheless, because her supervisors knew that she should have knew or should have known that she was working through her lunch, the company should have paid her for it, even though she didn't use the company's reporting system in this exception log to report the unpaid time that should have been paid. The Sixth Circuit Court of Appeals sided with the employer, and it focused its analysis on the right issue, which is if an employer knows or should have known that an employee is working, the employee has to be paid for that time. But, however, in this case, because the employee admittedly failed to use the employer's policies and procedures for reporting that unpaid time, the employer wasn't at fault. The court went on to say that under the Fair Labor Standards Act, the federal wage hour laws, if an employer establishes a reasonable process for an employee to report uncompensated work time, the employer is not liable for non-payment if the employee fails to follow those established rules. When the employee fails to follow reasonable reporting time procedures, the employee prevents the employer from knowing that it has an obligation to compensate the employee and thwarts the employer's ability to comply with the Fair Labor Standards Act. And so because the hospital established a system to compensate its workers for time worked during these presumptively unpaid meal breaks, and because the employee failed to use the system, unless the employee could show that the employer somehow, thwarted or somehow hindered the employee from using this reporting system, like logs got missing or told the employee don't write these down, whatever. The fact the employer has this policy for reporting overtime protected it from the employee's lawsuit for unpaid overtime. And case after case after case after case from courts all over the country have followed this rule from White versus Baptist Hospital. Earlier this year, from the Fifth Circuit down in Texas, similar issue. The employer had an overtime policy that prohibited hourly employees from working overtime without prior approval and required that all employees accurately report all working hours in its timekeeping system. The plaintiff in this case claimed she should have been compensated for overtime that she had worked but failed to report, or A, failed to get approval for, and B, failed to report. And the court disagreed and said, look, number one, the company has a policy, you have to follow it. And if an employee ignores the employer's policy, in this case, she didn't seek authorization and she didn't report her working time, then it's shame on the employee, and the employer doesn't have to pay the employee who, through the employee's own fault, doesn't follow a clear established policy or work rule about the approval or authorization of overtime. It wasn't, the company wasn't denying overtime to the employee. The company doesn't know about it. It doesn't have to pay if it doesn't know. And then number two, and what we see over and over again in these cases, we saw it in the White case, we see it again in this case from Texas, that policies trump constructive knowledge. That look, if you know or should know, as you said before, that an employee is working overtime, you got to pay it. You can't just ostrich the payroll. You can't just stick your head in the sand and say we're not going to pay you because we don't, see no evil, hear no evil. You can't do that. But if you have a policy that requires the approval and reporting, you can shift responsibility to the employee. And when that responsibility shifts, that policy is going to trump constructive knowledge every single time. So what's the lesson here? The lesson here is really to have a reasonable process in writing, preferably in your handbook, for employees to report uncompensated work time. Look, it's the employee's burden always in these cases to prove they were working. The employer doesn't have to prove the employee wasn't working, right? The employee has to prove they were working, and by having a policy that kind of underscores and highlights that burden for employees by saying, well, you have to document when you're working, and if you don't document it, we can't pay you, then that is really the company's best defense to defend against these kind of off-the-clock wage hour cases, which are expensive, expensive class actions for companies to defend. In the 10 minutes or so we have left, the last two topics we're going to talk about both fall under the umbrella of protected concerted activity. And protected concerted activity, just to kind of give a quick definition, under the National Labor Relations Act, employees, whether they are or are not in a labor union, have the right to, between and among themselves, talk about wages, hours, and other terms and conditions of employment. One area, and I said before, I gave the example before of the policy that is the most often violated. This is the one that I see that companies make mistakes on the most. I would say 1 out of every 2 handbooks I review contains a policy that says something like wages and salaries are confidential. Employees are not permitted to discuss with their coworkers how much the employee or any other employee earns. Employees that are found to violate this policy will be subject to discipline up to and including termination. That policy is absolutely 100% illegal under the National Labor Relations Act. Employees have the absolute right to talk between and among themselves about areas that the law protects: wages, hours, benefits, terms, conditions of employment, wages, how much they make. If you have a policy that prohibits salary discussions among employees and then discipline employees for exercising their rights to talk about how much they make, you're violating the National Labor Relations Act. And like I said, half the handbooks I review have these policies in them, and it comes out every single time because it is the easiest violation for the National Labor Relations Board to spot if a handbook comes its way in an unfair labor practice charge. But that's not the only area that the National Labor Relations Board is regulating in employee handbooks. The National Labor Relations Board has taken it among itself to expand the definition of protected concerted activity so far and so broadly that it now regulates just about every policy in the workplace that that has the potential to regulate workplace communications. You have, when we were talking about sexual harassment, we talked about confidentiality of internal, of harassment investigations. The NLRB says you cannot blanketly tell employees that harassment investigations are confidential, and you have to determine on a case-by-case basis whether you're going to, whether a particular investigation is or is not going to be confidential. And if you have a blanket confidentiality policy that says all workplace investigations are confidential, you have violated employees' rights to engage and protect their concerted activity, because there might be something in the investigation that touches on wages, hours, what have you, that employees might want to share and should have the right to do so. So says the NLRB. The EEOC, by the way, takes the complete opposite view and says all workplace investigations should be confidential, period. And I will tell you that the NLRB, even in its own administrative hearings, separates witnesses, doesn't allow witnesses to sit in hearing rooms and hear each other's testimony because of concerns about confidentiality and witnesses being able to tailor their testimony based on what other people said. So that's why we like these workplace investigations to be confidential, so we can get kind of pure, pristine, inviolate versions of people's stories, so we can kind of start putting the facts together to figure out what exactly happens. Prevents collusion. These rules of the NLRB kind of promote collusion by saying that you might not be able to keep workplace investigations confidential. Other policies that the NLRB takes issue with, like insubordination policies that say, be nice to each other, don't be insubordinate, don't yell, swear, curse, whatever. The NLRB says things like if a union is organizing, and which it's not, but if a union is organizing, employees might want to say nasty things to their coworkers that are not supporting the union. And so, because union campaigns get heated and get nasty, we can envision a situation by which somebody might want to, not be nice to their coworker and so forth, and therefore policies that require employees to be nice to each other and not to be insubordinate to their bosses are overly restrictive of employees' rights to engage in this protected concerted activity. Policies that prohibit defamation, policies that talk about workplace dress codes because they might prohibit someone from wearing a per-union insignia on the job. All these policies the NLRB has, has taken issue with. And let me just read a couple of examples for you so you can kind of see how fine of a line the NLRB is drawing. These I'm taking out of the U.S. Chamber of Commerce published like a 40 or 50-page report called "The NLRB Takes on the Employee Handbook: Theater of the Absurd." If you go to uschamber.org, maybe it's .com, one of the two, you can download a copy of the U.S. Chamber's report. You can kind of just see how far the NLRB has gone here to try to regulate workplace speech in the name of, harmonious workplaces and what have you. But really, what they're trying to do here, I think, is make it harder for employees to kind of regulate what goes on when a union is trying to organize. But take a listen to some comparisons of policies that are legal versus illegal. So here is a illegal, unlawful handbook policy according to the NLRB. Be respectful to the company, other employees, customers, partners, and competitors. That's illegal. A legal, lawful policy, by comparison, each employee is expected to work in a cooperative manner with management, supervisors, coworkers, customers, and vendors. I'm not sure what the distinction is between those two policies other than the words that are being used, but it is the NLRB is drawing such a fine, narrow distinction here. It's made it increasingly difficult for employers to write policies that touch on what employees say in the workplace and make them pass muster with the National Labor Relations Act. With that, I want to thank everybody. I'll hold it open for questions if people have any. Let me just make one point before I open the floor to questions, which is there are a million and one resources online for companies that want to draft or revise employee handbooks. There are templates galore online that employers can find to try to get a handbook in place for their companies. All these mistakes we talked about today are not, a handbook, like, depending on the size of your company, a handbook is going to cost you, in the neighborhood of $2,500 to have drafted for you. Each and every one of these mistakes will cost you some factor of that $2,500. It might be a factor of 4, it might be a factor of 10, it might be a factor of 100, depending on the size of the mistake and how many employees it impacts. But in my view, and again, this really isn't meant to be sales pitchy, that companies that try to cut corners by pulling handbooks offline, you don't know when those handbooks were last updated. A lot of what we talked about today is really cutting edge stuff that happened in the last 6 months, if not the last couple weeks. You don't know when that handbook was updated. You don't know for what state that handbook was written. If it's written by someone in California that threw it up online, it's going to have very, very different implications for employees than an Ohio employer. And so companies that kind of rely on these forms, these online forms, in my view, and you don't need to go to me, you can go to any lawyer who knows employment law. You're doing your company a disservice if you're relying on these online forms instead of getting at least a set of eyeballs trained in this area to put a look on your policy to make sure that you don't have a policy that is illegal or has otherwise been rendered illegal via these changes that are happening at really a rapid pace down in DC. So with that, I thank everybody, and I do want to hold the floor for questions. My contact info is here. I'm not hard to find. Phone numbers, email, website, blog, Twitter, LinkedIn. You can hit me up on any number of one of those ways, and I'm happy to take questions kind of offline as well. So, but with that, anybody have any questions?
All right, thanks, John. Just a couple of reminders before we get to those questions. This live webinar is eligible for 1 general recertification credit through HRCI. Make sure you complete the survey at the end of the webinar, and we'll send your certificate later this week. This webinar is being recorded, and everybody who has registered for it will get a link to it, and it will also be available on the website. And we have a couple of questions about what was 6 and 7 and what different numbers were things were. This is all going to be on the website, too, for you to take a look at. All right, first question. Can you discuss the difference between at-will employment and right to work?
Yeah. Ohio is not a right-to-work state, number one. Right-to-work means that you cannot force an employee to join a labor union or have their dues taken out of their paycheck to support a labor union. At-will employment is regards to somebody being, the reasons for letting someone go from their job. Someone can be fired or can quit or be fired at any time for any reason. We don't have indentured servants anymore. Somebody's free to walk away from a job at any time for any reason. And the company, for an at-will employee, can end the relationship at any time for any reason. It defines the reasons when an employment relationship can end. Right to work specifically relates to a union management where you have a collectively bargained workplace, employees that are work for a company, or in a bargaining unit pursuant to a collective bargaining agreement. If it's a right to work state, then the union, and by extension I guess the employer, cannot force the employee who works for that company to join the labor union or have dues taken out of their paycheck to support the union. So it doesn't have anything to do with the employment relationship at all. It really has to do with the relationship between the employee and the labor union that collectively bargains for the employees that work for that particular company.
Okay, thanks. The next question. Can we have our handbook online with a separate link to each section, and when we update the particular section, a date revised will be listed? We have the employee sign a form indicating they know it's housed online, so is that acceptable, or do you have to do anything else besides that when you update those policies?
Well, I mean, it really comes down to proof. There's nothing wrong with having an online handbook. Lots of companies have intranets with their handbooks online. There's nothing wrong with that. What I like to see as a lawyer for the company that's defending a lawsuit, to be able to prove to be able to have something to prove that the employee got the revision and put eyeballs on it, or had the opportunity to put eyeballs on it. And merely having it on an intranet where an employee may or may not go, may not be enough. So what I would like to see is, even if it's just a spreadsheet of, a check off, a spreadsheet of emails that went out that say that, on this date the handbook was updated, and we send emails to everybody, the following email address, and letting them know that the revised handbook was available on the website. are on the internet for them to look at. That's enough, I think. Ideally, I mean, a signature every time, but I understand the kind of the administrative burden of that. But just something that I can do, something that I can hang my hat on to show a judge or a jury to say, yes, the handbook was, the employee signed when they were hired, and the handbook was revised 4 times since they were hired, and each time that employee got an email that said that, you know, the handbook is, the following policies in the handbook have been revised. It's available at www.abccohandbook.com or whatever for you to review, you know, and please do so, or something like that. You know, something that I can hang my hat on to show that the employee knew that the handbook was updated.
All right, and I think that will do it for our webinar today. Thank you so much. We appreciate you once again, John, for doing this. And we look forward to our next presentation, which will be probably either in July or August of this year. So thank you all for attending. Everybody have a great day, and we'll talk with you soon. Thank you. Bye-bye.